How long does a car accident lawsuit actually take in Connecticut Superior Court? After a serious car accident in Connecticut, one of the most pressing questions injured drivers ask is how long the legal process will actually take from start to finish. The honest answer depends on several overlapping factors, including how long medical treatment lasts, whether fault is disputed, how complex discovery becomes, and how backed up the court's trial schedule is. Before a lawsuit is even filed, many injured drivers spend months reaching what doctors call maximum medical improvement because knowing the full extent of your injuries helps establish the true value of the claim. That medical treatment phase alone can last anywhere from 3 to 18 months after the accident, and it often runs alongside pre-suit demand letters and early insurance negotiations. Once a lawsuit is filed in Connecticut Superior Court, the case enters a structured series of stages that can stretch the total timeline to anywhere between 1 and 3 years, and sometimes longer if the case goes all the way to trial. Connecticut law gives most injury victims 2 years from the date of the accident to file a lawsuit under Connecticut General Statute, Section 52-584, with an outside limit of 3 years from the act or omission that caused the harm. Missing that statute of limitations deadline can result in losing the right to recover damages entirely, even when the injuries are serious and the other driver's fault appears clear. The pleading stage kicks things off when a summons and complaint are served on the defendant and filed with the court, and Connecticut practice includes a procedural anchor called a return date, which falls on a Tuesday and triggers early court deadlines. After the defendant files an answer, they may raise a special defense called comparative negligence, arguing that the injured person shares part of the blame, which can significantly shape how the entire case unfolds. Discovery is typically the longest stage of a Connecticut car accident lawsuit, involving interrogatories, requests for medical records and repair bills, and depositions of the plaintiff, defendant, treating physicians, and expert witnesses. Scheduling depositions alone can add weeks or months to a case, especially when both sides are investigating disputed liability and need to gather reconstruction evidence, review records, and prepare expert testimony. Before trial, the Connecticut Superior Court holds a trial management conference where the judge reviews readiness, schedules, disputed issues, exhibits, and any remaining settlement possibilities. Cases involving serious injuries, multiple defendants, or heavily disputed fault tend to take longer because each of those factors adds more parties, more records, more scheduling conflicts, and more legal complexity to the process. Having an experienced attorney in your corner from early on can help keep discovery organized, deposition preparation focused, and your legal strategy aligned with the realities of how Connecticut courts actually move. The law firm of DeFronzo and Petroskey represents injured clients throughout Waterbury and the surrounding Connecticut communities, guiding them through every stage of the Superior Court process, from initial filings through trial preparation. If you have been injured in a car accident and need to speak with a lawyer about your case, call DeFronzo and Petroskey, PC at 203-756-7408, located at 255 Bank Street, #2B, Waterbury, Connecticut 06702, United States, to schedule your consultation today.